Hello everybody. This is a case analysis of a PPO or private placement offering by Richard Arias for Dr. Shahrokhi's Fin 139 class at CSU Fresno. A PPO or private placement offering comes about when a small business or a startup company needs to raise capital. Typically, an individual investor or a small group of investors will be approached by the people who are handling the issue of the securities. Sometimes the investors are entrepreneurs themselves, and this can benefit the startup company if certain synergies can be made. As part of the PPO, debt is offered or a large amount of equity which is offered at a deep discount to market value. The PPO can occur as an initial round of financing or as a later round of financing. It just depends on the position of the company, what stage they're in. And also, a PPO is less costly than an IPO. Lots of broker fees and underwriting fees are cut out. The PPM, or private placement memo, is the key document in a PPO. It acts as a prospectus for the shares that are being offered. The focus of the PPM is disclosure. This disclosure can protect the issuer from potential litigation down the road. The key here is to disclose all key terms and risk factors to the potential investors. A PPM can be created by attorneys and accountants, investment bankers, or PPM specialists. Whatever the case, attorneys and accountants are necessary for both sides. The parts of the PPM mainly consist of a cover page, which lists such information as the name of the issuer, the number of shares being offered, along with share price. The term sheet, as given by the issuer, this is a summary of the issuer's key terms to get the deal done. There are legal disclaimers. These help to avoid litigation. Risk factors are also disclosed, both generic and specific. Capitalization is also listed before and after the offering. That way the dilution of the shares can be looked at. Also included is a subscription agreement. This is a contract that needs to be signed for the shares to be sold. Along with that is an investor questionnaire, and this is used to qualify the investor or to see if they are sophisticated or accredited. Regulations that pertain to a private placement offering come in two forms. The main form is federal regulations. For private placements, it is the most common type of private placement is under Regulation D, which came about in 1982, and this gives an exemption from having to file with the SEC. It comes in three different forms. Rule 504, which is offerings up to $1 million and all types of investors. Rule 505 is an offering up to $5 million with an unlimited amount of accredited investors and up to 35 non-accredited investors. Rule 506 has an offering that is unlimited. The dollar amount is unlimited. Also, the amount of accredited investors is also unlimited. What changes here is that there are up to 35 sophisticated investors allowed, which basically that will be judged by the issuing company to determine if they are worthy of the investment offering. As far as state regulations, the score system is used, small corporate offering registration. This is a Q&A format that makes it easier to draw up disclosure documents. This aligns with Rule 504 and is typically used for offerings of up to $1 million. Blue sky laws or state laws also apply. It just depends on the state that the offering is occurring in. There may be pre or post sale registration or notices that need to be complied with, special disclosures and agency rules which state who can act on behalf of the issuing company. Due diligence is key in a PPO. This is basically the issuer and the investor doing his or her homework to get the value that they deserve from the deal. A due diligence checklist is often created for investor and issuer alike. For the issuer, it is important to review 3 key areas. 1 being the use of proceeds, 2 a review of business model and budgets, and 3 a legal review to avoid litigation. From the investor's perspective, they will be reviewing management skills, sales and marketing strategies, financial, tax, and legal aspects, as well as looking at the board of directors and the business plan to make sure it is sound. The investor will assess all data to confirm that the deal is what it is. The term sheet from the investor is a conditional offer basically stating what the investor wants to finance the deal. This can reduce the value for the issuer if they do not negotiate with an attorney. Terms that are commonly set out by the investor pertain to preferred stock, dividends, voting rights, composition of the board, liquidation preferences, anti-dilution provisions, and drag-along rights. In conclusion, a PPO has many moving parts. The PPM, the due diligence that must be conducted by both issuer and investor alike, and the negotiation of the term sheet with an attorney are a must for a deal to go through. A well-orchestrated deal gives value to both the investor and the issuer. Meeting this balance is what allows new business to flourish. Thank you for listening.